Welcome, everyone. We will be starting at 2 p.m. Thanks so much for joining this panel today. Good afternoon, everyone. We are going to get started in just a few seconds. I think a lot of folks are rolling in since it's 2 p.m. now. So we'll give them about 30 more seconds to log in, and then we'll get started. All right, we're going to go ahead and get started. I want to first start by saying thank you to you all for joining this virtual panel on fair housing presented by the Indiana Civil Rights Commission. As you may know, April is Fair Housing Month as it marks the anniversary of the Fair Housing Act being signed. We're excited to learn more about fair housing from our wonderful panelists, but before we jump in, let me introduce myself. My name is Ann-Therese Ryan. I'm the Public Outreach and Education Manager here at the Indiana Civil Rights Commission. I'm honored to serve as the moderator for today's panel as well. I'd like to get started with a few housekeeping notes. We want to first mention that this webinar is being recorded, and the recording will be made available on our website and our YouTube channel tomorrow. To access captioning for this webinar, click on the button titled More on the toolbar. In the drop-down menu, select Settings. A second menu will pop out. Click Accessibility. On the side panel, slide the toggle to the right to turn on captions. The instructions for turning on captions will be dropped into the chat. If you experience any technical difficulties during the webinar, we recommend that you try leaving the webinar and then rejoining. If you continue to experience technical challenges, let us know in the chat and our team members can try to help you troubleshoot. Please also note that the recording of the webinar will be available tomorrow and you can view it on your own availability. Today's webinar will begin with presentations from each of our panelists and will conclude with a questions and answer session. If you have questions throughout the panel, please click the chat button on the toolbar and type in your question. If time permits, our panelists will be able to answer any audience submitted questions. So let's get started with introducing our panelists. Today we'll hear from David Fleischhacker from the Indiana Civil Rights Commission, Ronell Tomlinson from the Ohio Civil Rights Commission, and Kylene Welling from the Indiana Housing and Community Development Authority. We're excited to hear from our partners as they come together to share their unique perspectives on fair housing. So we'll begin with hearing from our Deputy Director, David Fleischhacker. David joined the Indiana Civil Rights Commission as Deputy Director and General Counsel in November of 2021. Prior to joining ICRC, David served over 4 years as the Employee Relations Deputy Counsel in the Indiana State Personnel Department. In his 12-plus years of government service, he has also worked as a staff attorney for the Indiana Department of Correction and in various roles with the Office of the Indiana Attorney General. David has also been an adjunct faculty member for the IUPUI School of Liberal Arts for over 10 years, regularly teaching the Fundamentals of Speech Communication undergraduate course. David holds a JD from the IU McKinney School of Law, as well as an MPA with a nonprofit management concentration and a BA in Communication Studies also from IUPUI. Thank you, David, for being here today, and you can take it away.
All right, thank you, AT. And let me go ahead and start sharing my screen. All right. So as AT mentioned, my name is David Fleischhacker. I'm the Deputy Director and General Counsel for the Indiana Civil Rights Commission. And today I'm going to be providing a kind of a general overview of fair housing laws within the state of Indiana and kind of how ICRC fits within that realm or that area. So wanted to get started. And first off, I would be remiss as an attorney if I didn't include any disclaimers. First off, the Civil Rights Commission doesn't make the laws. We enforce them. The General Assembly is tasked with making the civil rights laws for the state of Indiana. This presentation is only for educational purposes and is not to be construed as legal advice. For legal advice, we suggest that you contact a private attorney. And this presentation provides general information and guidelines and is not to be considered official ICRC policy. Now, why is it important to talk about fair housing? And as AT mentioned earlier, April is Fair Housing Month. So it's a great time to talk about it. However, we should be talking about it all year long, but it's a great month to focus on it. And this year, not only do we celebrate the 55th anniversary of the Federal Fair Housing Act, but we're also celebrating the 60th anniversary of the Indiana Civil Rights Commission in its current form. And while some things have improved during that time, much work remains to be done. As you can see, in 2021, the National Fair Housing Alliance reported over 31,000 fair housing complaints across the nation, which was an 8.7% increase from the prior year. And just here at the Civil Rights Commission, we processed 164 housing-related complaints in 2022. And there's some other reasons as well. The increased cost of housing, both rentals and for purchase, have significantly impacted housing availability and affordability, which all plays into fair housing. The Federal Reserve reports the average sales price for a house in the Midwest region peaked in the second quarter of 2022 at $4,378,700. And that was up from $338,500 in the fourth quarter of 2020. And for those of you who don't math quickly, that's a year and a half difference of roughly $100,000 in the average sales price for a house. And then according to rentdata.org, the average fair market rent price across Indiana for a 2-bedroom unit has increased from $760 a month in 2018 to $826 a month currently in 2023. In the Marion County area, the current fair market rent price for a 2-bedroom unit per month is $1,065. So all those things play into why it's important to talk about fair housing. So in my brief presentation, I'm going to do a brief overview of the Indiana Fair Housing Act, talk about the protected classes in Indiana, discuss what discriminatory acts are and when they can occur, and then briefly go into kind of what ICRC has jurisdiction over and what our process is when we get a complaint into our office. Now, the Indiana Fair Housing Act, found in Indiana Code 22-9.5-1-1, provides kind of three purposes, and one's to provide fair housing practices in Indiana, another to create a procedure for investigating and settling complaints, and then to provide rights and remedies substantially equivalent to those granted under federal law. And that provides us with an opportunity to work with our federal counterpart in HUD to investigate housing-related complaints. Now, from a legal standpoint, discriminating between individuals is lawful unless it is prohibited by law. For example, an employer may discriminate between applicants because of level of education or work experience. And in the housing area, a landlord may, kind of generally speaking, discriminate against applicants on the basis of their credit worthiness or ability to pay for a rental unit, or someone selling their home may favor a cash buyer over other potential buyers. However, state and federal law specifically prohibit discrimination as it pertains to certain protected classes, which we'll discuss in a little bit. Now, the Fair Housing Act provides or protects people from discrimination when they are renting or buying a home, getting a mortgage, seeking housing assistance, or engaging in other housing-related activities. Now, every situation is different and unique, and because of that, we as the commission have to conduct thorough and comprehensive investigations of each situation to see if a discriminatory housing practice occurred. But ultimately, everyone should have equal access to housing, and that's what the purpose of the Fair Housing Act is. So now, who is subject to the fair housing laws? And first, there are the individuals that we often associate with housing. You got sellers, landlords, leasing agents, etc. But the law is silent as far as who can be sued. So pretty much any persons or organizations engaged in providing housing are potentially liable, including realtors, salespersons, homeowners associations, etc. And those entities can be held liable for the conduct of their agents and employees as well. There are some exceptions, which we won't go into right now during this presentation, but there are some exceptions to those individuals. But even within those exemptions, there are exceptions to those exemptions as far as, if individuals are making a discriminatory statement or advertisement indicating a preference based on a protected characteristic, things of that nature. And then who can file a complaint under our fair housing laws? And it's fairly broad. Virtually anyone who has been impacted or can show that they've been harmed by a discriminatory housing practice is going to be able to file a complaint under the Fair Housing Act. So I mentioned earlier protected classes, and under the Indiana Fair Housing Act, there are 7 protected classes: race, color, religion, sex, familial status, which indicates members of the family who are 18 or under, which would, or under the age of 18, residing on the property, which would include pregnancy-related complaints. Then you have disability and national origin. And then in Indiana, under the Indiana Civil Rights Law, ancestry would also be a protected class for housing cases under the Indiana Civil Rights Law. So then in looking at protected classes, we're looking at, those are the individuals against whom discriminatory acts can occur. And we're primarily looking at 2 different types or forms of discrimination. The first form would be disparate treatment. And this is going to be the one that most people think of when they think of housing discrimination or discrimination in general. It's when they treat people in a protected class less favorably than others not in that class. For example, I will rent to white applicants, but not to Black applicants. I will charge Catholics $400 in rent, but non-Catholics $800 in rent. There, you're treating one class differently than another class. And in these situations, you're kind of looking at what is being done to comparators or somebody who's similarly situated to that individual, but of a different protected class. And the fact that they're being treated differently is the evidence of the disparate treatment. And that's a little bit different form than what we look at in a disparate impact case. And there we're looking at the result of a facially neutral rule or policy, regardless of its intent, and looking at, does it have a disproportionate impact on a protected class? So is there a negative outcome for a protected class based on this facially neutral rule or policy? So we've got these two different forms of housing discrimination. So when can these violations or when can these discriminatory acts occur? So some of these situations can occur pre-sale or tenancy. These would be situations of a refusal to sell or rent, steering, where maybe a real estate agent or landlords steering individuals to a particular location or housing area based on their protected class, false representation of availability, or requiring different terms and conditions, maybe additional requirements based on the protected class. Now, during tenancy or homeownership, similar violations can occur, different terms and conditions, maybe providing more timely maintenance for one class versus another class, or treating individuals differently when violations of a lease would occur, and treating a protected class more harshly than another similarly situated individual. You also have situations of coercion, intimidation, threats, and interference. If somebody's trying to enforce or play out their fair housing rights, and they're then being intimidated or threatened because of that. During their tenancy or home ownership, you also have situations of reasonable accommodations or modifications that are being requested, and there might be situations where that's denied. And actually, Renell will get into that later in this panel. And then situations of harassment could be the landlord or one of the property management company harassing or sexually harassing a tenant. But even beyond that, in 2018, the Seventh Circuit held that management or a landlord can be held liable for failing to take available remedial measures to prevent harassment between two tenants if the landlord knows that severe or pervasive harassment has occurred. So if it's been reported to the landlord or the management and they don't do anything about that harassment, then they could be held liable for that as well. And then our third scenario would be situations that would end home ownership or tenancy. Here you bring into things about eviction, if you're evicting a certain protected class versus another, or maybe initiating eviction proceedings after like an accommodation request, refusing to renew, engaging in retaliation, things of that nature that might end somebody's tenancy in violation of the Fair Housing Act. And then another type of discrimination that's gotten a higher level of focus on recently is related to criminal background policies. And the Fair Housing Act, as we mentioned before, in kind of disparate impact situations, prohibits housing discrimination and practices that have an unjustified discriminatory effect on a protected class. Just kind of some background information. In an October 2021 report, the Sentencing Project found on the national level, Black Americans were incarcerated at nearly 5 times the rate of white Americans, and Latino Americans 1.3 times higher. In Indiana, the rate of incarceration for Black Americans was 4.5 times that of white Americans. So blanket denials of those with a criminal record from renting or buying likely have a disparate discriminatory impact on the African American and Latino communities. So selective use of criminal history as a pretext for unequal treatment of individuals based on race or other protected classes would be considered illegal discrimination. And it's a best practice to assess each person on a case-by-case basis. That would be kind of a best policy. And that would be taken into consideration the nature and severity of the conviction and the amount of time that has passed since the criminal conduct occurred. So now, what does ICRC have jurisdiction over? You know, your fair housing rights and obligations in Indiana come from three different sources of law. We have the Indiana Civil Rights Law, the Indiana Fair Housing Act, and the Federal Fair Housing Act. The Indiana Fair Housing Act is designed to be substantially equivalent to the Federal Fair Housing Act, as I mentioned before, and that allows the complaints filed with HUD to be resolved by the Indiana Civil Rights Commission or in state court as it may get filed. And then ICRC strives to, through our statewide grassroots efforts, to partner with local community leaders, community organizations, government agencies, private partnerships, and educational institutions to create more awareness about the Indiana civil rights laws and fair housing laws. So what does that kind of look like in practice? In Indiana, I mentioned our 7 protected classes, 8 if you include ancestry under the civil rights law for fair housing, but overall there are 11 protected classes under Indiana civil rights laws. In 2022, 32.5% of our complaints that came in were filed by individuals who claim disability as a protected class. 31% were race, and 17% were in sex. And in our enforcement areas, in addition to housing, we have 4 other enforcement areas, and 73.5% of our complaints, the vast majority, were in the employment area. However, 16% were in housing, 7% in public accommodation, and 3.5% in education. Now, AT is giving me the countdown, so I'll try to speed up here so we can move on to our other speakers. If you want to, we hope that you never have to file a complaint, but we do try to make it easy if you do. You can call, email, walk in, go to our online complaint portal. It has Google Translate on it with over 100 different languages that you can file your complaint. We want to make sure that you get that complaint signed, state all of your allegations, and then draw a clear nexus between the protected class and the alleged discriminatory act. You have 1 year to file under the Fair Housing Act and 180 days to file under the Indiana Civil Rights Law. We have multiple areas that work through the process when a complaint comes in. The intake division serves as our first responder, kind of triaging and assessing whether or not we have jurisdiction. Already through the end of March of 2023, we have formalized 327 complaints, which is over 200 more complaints than we did at the same point last year. And we've seen a 42% increase in housing complaints so far in 2023 in that same time period. If we do have jurisdiction, it moves on to our investigation area where they look into the complaint and determine whether or not a discriminatory act occurred, and conducting interviews with parties, collecting documents that are all necessary to determine, to figure out what went on in the scenario. We serve as that neutral fact finder to determine, kind of get to the truth of the matter. And then finally, our litigation section works, if there is a cause determination found after the investigation that discriminatory act more than likely occurred, our litigation team would take over and advance and represent the public policy or public interest at that next level before an administrative law judge or a superior or circuit court judge to provide relief for that aggrieved party. Now, I also, on the kind of little wheel there, you see alternative dispute resolution. I wanted to do that separately. Our ADR team they serve there and conduct mediation and settlement conferences to try to get parties to resolve the complaints that come into our office. And over the last 6 years, through our settlements of cases, we've recovered over $3.1 million in relief for those for the complainants. And just this last year alone, over $756,000 was recovered, a 37% increase over the prior year. And in addition to this monetary relief, we also work to provide affirmative relief to, could be training, could be, signage, posting, things of that nature to help prevent that discriminatory act from occurring again in the future. And that concludes my portion. I apologize if I went over by a few minutes, AT, but I will turn it back over to you, and I thank you.
Thank you, David. I will say I always learn something new whenever I hear David present. So thank you so much for being here and sharing. I'd like to introduce our next panelist, our next speaker. Our next speaker will be Ronell Tomlinson. For more than 20 years, Mr. Tomlinson has been the Director of Housing Enforcement and Director of Mediation and ADR Services for the Ohio Civil Rights Commission. He also serves as the Commission's liaison with the U.S. Department of Housing and Urban Development, working closely with HUD in the investigation of housing cases. Together with the Commission's Executive Director and Director of Operations, Mr. Tomlinson works to develop and implement the Commission's housing and mediation policies and procedures. He is a nationally recognized expert in housing discrimination cases, serving on panels and providing trainings to attendees at HUD's national policy conferences and regional trainings. In his tenure at the Commission, Mr. Tomlinson has worked extensively with fair housing cases that negatively affect and impact people with disabilities, and he has provided his expertise and knowledge about accessible design and new construction for covered multifamily dwellings, as well as reasonable accommodation and reasonable modification cases. Mr. Tomlinson joined the OCRC in 1997 as a legal intern while attending Capital Law School in Columbus, Ohio. He received his Bachelor of Arts in Journalism from the University of Oklahoma in 1993. Boomer Sooner. I'll turn it over to you, Ronell.
That's a great intro, and particularly the Boomer Sooner. Good morning, good afternoon, everyone. I am so excited to be talking and doing some training for April Fair Housing Month. And when the previous speaker, David, was talking about the Fair Housing Act being 55 years old, I started thinking, which is, 55 and older housing is what's also covered under fair housing. So I guess the Federal Fair Housing Act has now earned the right to be able to exclude children from living in certain places where you ordinarily would. So anyway, what I'm going to focus on with my presentation is going to be disability, okay? So I've spent a lot of years on disability. And before I go any further, let me make sure you understand I'm with the Ohio Civil Rights Commission. The link to the commission, crc.ohio, spell it out, .gov. Again, the link to the commission's website, crc.ohio.gov. And then the phone number is an 888-278-7101. Again, 888-278-7101. So there are three areas for which I want to cover this afternoon, which is under our statute, which is design and construction, which is building apartment complexes and condos where you've got 4 or more units that are joined together, that as of 1992 on the state statute that we enforce, which is the Ohio Revised Code 4112, that was in 1992, and under the federal statute, that occurred in 1991. Then I want to also discuss with you reasonable accommodations as well as reasonable modifications, okay? So I'm going to begin with what we call the failure to design and construct covered multifamily dwellings for first occupancy on or after June 30th of 1992. So what I want you to do is just visualize yourself when you may have been younger, and I'll use the apartment complex thing because that's what we see quite often, which is in terms of your understanding, what are those design things that are covered under the state and or federal statute, which is, think about when you drive to an apartment and you're looking to view it. So one of the first things you do is you find a parking space, correct? So the parking space has to be accessible. And then there has to be a curb cut so that you can then get up onto the sidewalk. And then that sidewalk is also one of those areas that is covered under the act, because you have to have a nice smooth surface so that the person who would be in a wheelchair or someone walking using a walker can easily get to the rental office. Okay? So now that we're at the rental office, I want you to perceive that, okay, if you were a person with a disability or you're in a wheelchair, or if you were using a walker and you had difficulty ambulating, I think we can all agree that steps in the front door would be problematic for you, okay? So therefore, under the failure design and construction of new multifamily dwellings that are built again after 91, 92, there can be no steps at the entryway to the front door. So now you've eliminated that. So now once I get ready to operate the door, walking into the rental office, okay, that door has to be of a certain design. It has to have certain measurements, which is there has to be 32 inches of clear floor space when that door is open ajar, okay? And the handle cannot be something that would require you to grasp and twist and turn, okay? Because if someone had a disability that affected their hands, they want to be able to just push down on that level handle, is what they call it, okay? So then once you get inside the rental office, okay, you're then going to make sure that if there's water fountains provided in there, or if the rental office may be connected to a community room, or if it also leads to the actual let's go where the swimming pool is. All of these areas have to be accessible to someone who would be disabled. Okay, so now that we've covered those areas, which is what we call the common and public use areas. Okay, so throughout the whole unit itself, every pathway has to be 36 inches wide so that I, as a person who's disabled, and it also has to be a smooth surface, can navigate easily, okay? Now, let's take you over to the actual unit that you may be living in for the next phase of accessible design dealing with multifamily dwellings, okay? So therefore, again, when I get to my unit, there needs to be a disabled parking space that is required to also have access aisle, that is required to have the curb ramps to get up on the sidewalk. And then once again, when you get to the front door, as I stated earlier, you cannot have any steps to enter the door. In fact, the biggest amount of obstacle that can be there can be no more than a quarter inch in height, which is what we call the threshold. Okay, because under for every door, there's typically some sort of a sweeping device that's there that prevents air from getting in. So therefore, that can be no more than a quarter inch. Okay, and then once you get inside, there are the environmental controls, which also have to be at certain reach ranges so that the person who's disabled can actually operate those things, as well as the kitchen, as well as the bathroom. They have to be also designed so that a person who would be mobility impaired can also be able to operate those things and use them. So in essence, when you think about multifamily dwellings, it's about usability is what it is, okay? So let me move on into one of my favorite areas, which is reasonable accommodation, okay? And then there's also reasonable modification, okay? So I'm going to go to reasonable modification first because that is purely saying that you as a person who's disabled can make reasonable accommodations to rules. I mean, you can make reasonable modifications of any existing housing accommodation. This does not have to be an apartment complex. This could be a residential home, okay? So there's another part of the statute that said and recognized that prior to the ADA being passed, there was not really any mandate to build anything to be accessible. So the part of our statute, which is under our state, it's also under federal statute, is you must permit a person who would be having mobility issues to make reasonable modifications of those existing housing accommodations. And as long as there are no federal dollars flowing into this apartment complex, okay, then it's going to be the onus upon the actual renter to actually pay for and contract with other people to make those modifications. Those modifications can be nearly anything and everything to the structure. But please recognize, again, that prior to 1990, there was no federal statutes that was out there that required developers who were building apartment complexes and building condominiums to make sure that they would be accessible. In fact, from my work with the commission, I began to realize from other stuff, which is the bulk of the housing that has been built in this country was built prior to these statutes going into place. So you're looking at a plethora of available housing that basically is unusable to someone who would be mobility impaired. So therefore, the feds were very smart to include the provision about reasonable modifications, okay? Now, let's move on to reasonable accommodations, okay? That's, you should be permitted as a person with a disability to make reasonable accommodations and rules, policies, practices, and procedures whenever it would be necessary to afford a person with a disability equal opportunity and use of the dwelling, including the public and the associated public and common use areas, okay? So typically with my agency, the bulk of the things that we see on these cases is going to be the people that will not allow someone who is a person with a disability. And in terms of that person with a disability, for the reasonable accommodation and/or the reasonable modification, you have to be able to present to the owner of the property a documentation that would indicate that you are going to be needing the modifications and or the accommodation so that they can have full use and enjoyment of housing accommodation. Okay. So that reasonable accommodations for, in general terms, could be a change in the policy in terms of if I'm a person that's on SSD, so the Social Security and Disability Benefits, that from my understanding of that, it's based upon your birthday of when they make the payment for. So if the day of your birthday falls later in the month, then obviously you're not going to be getting that check until later in the month. So therefore, that would be a change. Another change in rules and policies would be requesting that the owner give you a disabled parking space exclusive to your usage. Again, as long as you have the information that indicates I'm a person with a disability and I'm needing this accommodation, this modification, so that I can have full use and enjoyment of the housing accommodation. Okay. And then here's the part that I love about this law, which is it's dealing with an emotional support animal. Okay. And so in essence, most animals could be an emotional support animal. Okay. Now I know sometimes when I've done trainings like this before, people have said that, oh, Ronell, what if they're wanting someone like wanting a hippopotamus and or an elephant? And I'm just go, that's preposterous, because everyone understands that in a housing situation, you're not going to have the saber-toothed tiger. You're not going to have the woolly mammoth, okay? But you're going to have animals that we all may come to understand. So one would be, I had a case that was dealing with chickens that were emotional support animals. I've seen cases where a gentleman in Ohio who was a former veteran who was suffering from PTSD, he needed ducks. It took this particular city probably a couple of years before they finally understood exactly what that statute was in terms of allowing him to have it, because it alleviated many of the symptoms that he was having from PTSD. The same was true with the woman who had the chicken cases. And then also when I was mentioning earlier, there you could also be looking at a miniature horse, but also understand a miniature horse is not going to be in like an apartment complex. It may be in a residential home, which is the cases I've seen where the chickens and the miniature horse. Okay, we had a miniature horse case down in the city of Cincinnati, and with this particular case here, as strange as it may seem, what we always do at the commission is we want to see the documentation from the healthcare provider that would show a nexus and or connection to the disability and the requested accommodation, or whether it's the modification as well. So in this particular instance here, the young daughter of the mother who lived in this residential home, she was being treated at a hospital down in Cincinnati, and this particular hospital specialized in things that dealt with exactly with the disability that the mother's daughter had, which impacted her cognitive skills as well as her mobility issues. Okay, so once we saw that she was being treated there, then I knew for certain, okay, that this was going to be a request that the city was going to have to allow, okay? Because again, as I'm establishing here, as long as there is healthcare provider documentation that establishes that the person is a person with a disability and there's a nexus connection to the requested accommodation and or the modification, you must grant it. Now, clearly, I can talk about a whole lot of other things here in terms of disability, but I think these two examples on the chickens and the miniature horse, then you would obviously know that dogs and cats will be always available to be an emotional support animal, okay? At the commission, we see the most cases on disability, okay? That's where we see the most cases. And I think race and familial status are the next two. And then as with the previous presenter before me, all of those protected classes that he reeled off are all of the same ones that we have, okay? Thank you very much, and I'll yield.
Thank you so much, Ronell. Just gonna quickly share. All right. I would like to introduce our next speaker. Our presentation is coming from Kylene Welling at the Indiana Housing and Community Development Authority. Kylene has been a public servant for 17 years, serving as general counsel and chief operating officer for 2 Indiana lieutenant governors before joining the Indiana Housing and Community Development Authority in 2015 as chief of staff and chief operating officer. Kylene has a lengthy background in federal program administration, having served as legal counsel to agencies administering the Community Development Block Grant Program, Emergency Food Assistance Program, Conservation Reserve Enhancement Program, as well as many other state-funded programs. She currently serves as the leader of teams administering Indiana's emergency rental assistance, energy assistance, weatherization, and homelessness service grants. Kylene is a graduate of Michigan State University with a bachelor's degree in interdisciplinary social science with a cognate in anthropology. She graduated from the Indiana University McKinney School of Law and is admitted to the Indiana Bar. Thank you so much for being here, and I will turn it over to you.
All right, good afternoon. Thank you for having us. All right. All right. Well, I am Kylene Welling. I'm from the Indiana Housing and Community Development Authority. We are our state's housing finance authority. Our mission here is to provide housing opportunities, to promote self-sufficiency, and to strengthen communities. Every state has a housing finance authority. They are state chartered authorities that are established to help meet affordable housing needs within their state boundaries. They use various mechanisms to finance the creation of new affordable housing or the remediation of existing housing using a combination of bonds, tax credits, and certain specific federal programs that are designated for that, as well as some state resources. Most HFAs administer programs dealing with home ownership, rental assistance, or rental creation type programs, and special needs housing. And also many state HFAs, like the Indiana Housing and Community Development Authority, we administer other federal housing programs, such as the Housing Choice Voucher Program, often called Section 8, utility assistance, rental assistance, as well as providing administrative funding to typically nonprofit or local government organizations that serve Hoosiers experiencing homelessness. Sorry, my screen is not advancing. IHCDA specific info, we were actually established in 1978 by the Indiana legislature. We are not a traditional state agency. That is why we are allowed to administer debt and issue bonds on behalf of the state. We share that role with the Indiana Finance Authority. We do administer a variety of federal grant programs, as well as a few small state programs. And in most of those, we act in a pass-through capacity where we are re-awarding those dollars out to a subrecipient across the state. The majority of our programs are statewide. When we do work with the U.S. Department of Housing and Urban Development, they do have a few carve-outs for what they call entitlement communities, and in some instances, there are certain areas of the state that we do not serve with all of our programs. Because of that, one of the roles we really relish here is acting as a convener of various groups in the housing services industry, bringing people together to talk about issues and challenges and opportunities facing the housing industry. And I want to highlight quickly one of our most recent endeavors in that, which is our new Indiana Housing Dashboard. This came about of a commission that the Lieutenant Governor's office brought together to really study housing issues across the state. And it's an amalgamation of a lot of pre-existing data, but it brings a lot of data sets together around housing, housing affordability, jobs, and different geographic type information. I encourage you to visit that. I will make sure AT has my presentation. There's a lot of great ways that you can sort and compare this data across different counties and different geographic boundaries around Indiana. So it is a good resource. Also, it does have some of the same statistics David was talking about earlier, a little bit about, average rental prices and how those have increased over time. The same with median home prices and things like that. A little bit about what IHCDA does related to fair housing. We are not an enforcement type agency, but we do recognize the importance of fair housing and do some activities around that every year. We are one of the sponsors of the Fair Housing Center of Central Indiana, the organization. We also help sponsor their annual conference, which I believe just happened a couple weeks ago. We do partner with the Civil Rights Commission to survey fair housing violations in Indiana through testing. We have an ongoing testing program with them. We obviously require our subrecipients to comply with the Fair Housing Act. IHCDA serves as the collaborative applicant for the Indiana Balance of State Continuum of Care. That is the group that represents 91 of 92 counties here in Indiana with homelessness administrative type services and funding. So we are currently working with them to do some research around housing equity around the services that are provided with different funding streams, mostly HUD funded as well. And then also we partner with the Indiana Office of Community and Rural Affairs on several activities. One of those that we will be working with them closely on is to help incorporate and implement some changes to the affirmatively furthering fair housing HUD rules for our HUD funded programs. And to make sure that we have taken a deep dive and updated a lot of that information for next year's State of Indiana Consolidated Plan, which is required for HUD programs, particularly CDBG, ESG, HOPWA, and HOME. A little bit more about just the general activities we undertake. One of our biggest programs is our home ownership programs, where we provide various programs to help with closing costs, down payments, provide low interest loans, mostly to first-time home buyers, but we do have some programs that work with folks that have been homeowners before. Last year, we helped over 2,500 Hoosier families participate in home ownership. We also have some, the Home Investment Partnership Program can also provide some home buying supports, mostly to nonprofit builders. We often see our subrecipients for that program being local Habitat for Humanity groups that want to construct single family homes. Our multifamily is probably our largest portfolio of housing financing tools. Those are typically our rental housing tax credits, which is a federal program, the Home Investment Partnership. We do have a little bit of state money, and then we have a new state tax credit program that we'll be launching later this year. And that is the first time the state of Indiana has earmarked tax credits for affordable housing development. So that's very exciting. We also do some placemaking with nonprofits or local units of government through our Creating Places. It's a crowdfunding, crowd granting type program. I encourage you to check it out as well. Some really cool projects, really helping to create that sense of place in our communities. I was also asked to briefly touch on some of the other programs we provide around housing and utility assistance. We currently are administering the state's emergency rental assistance program. This is another one. We serve 90 out of 92 counties with that program currently. Through that program, you can also receive housing stability counseling, which could be anything from learning how to make a budget to job training to gaining access to childcare, whatever that family needs to stay stably housed. We do provide those services through a network of partners statewide. We have dollars earmarked for eviction prevention and legal advice. We actually have navigators in several of our counties physically in the courthouse providing on-the-spot legal advice to those facing eviction. And also there are opportunities for households to apply for rental and utility assistance benefits through that program. We also are currently running the Homeowner Assistance Fund. This is another federal program sponsored by the United States Department of Treasury. They also provide housing counseling around helping families stay housed and work on affording that home that they are in. They can also provide mortgage assistance in the form of catch-up payments or some ongoing forward-facing payments to make sure people stay current. Also, great opportunity. This program allows us to pay homeowners association fees, property taxes, some of those other fees that a lot of programs don't address that can also really reduce the burden on those households and help them achieve success in staying housed. One of our, before our rental assistance program existed, obviously one of our largest programs is our utility assistance, or LIHEAP. That is an annual program through the Department of Health and Human Services that provides utility assistance for any kind of fuel source to heat your home. So electric, gas, fuel, bulk fuel, propane, wood, we do it all. Also, through our local network of providers, households can apply to have their heating and cooling equipment repaired or replaced if it is not functioning or not functioning efficiently. That program can provide crisis benefits during the program year to help avoid disconnection and bring households current on what they owe to utility providers, and also has an energy education component, which can help households understand how they can be more efficient and use energy more efficiently. As part of a COVID Relief Act, we also have currently a water assistance program called LIWAP, and that is utility benefits exclusively for water or wastewater to households. And our utility assistance programs are open to homeowners or renters. So those are, you can be either, you can have your utilities combined in your rent, you can still be eligible to receive a utility benefit, even if you don't directly pay any of your bills to a utility company. There are options for that as well. So we do have some websites devoted to those different programs. Also, our IndianaHousingNow.org is another great resource where we work year-round with particularly our partners that we have helped finance the construction of new affordable housing or the remodeling of existing affordable housing. They are required to list all available units they have in those properties at IndianaHousingNow.org. So it's also a great resource for those looking for new rental properties. To check, you can also sort and filter by different communities, different counties or cities that you want to be in. And also there is information on that website. There's actually a hotline that is part of that service as well, where prospective renters can call in and ask questions. All of our rental assistance, mortgage assistance, and energy and water assistance programs you can start those applications online, or you can also call 211 for assistance or to be referred to a local provider in the community that can help with filling out any of those applications. Another program that we do that helps those with disabilities remain in their house is the Ramp Up program. This is a small program we operate by providing funds to small nonprofits that do this work. But this is very important to help with aging in place and also just keeping homes accessible. We create a lot of ongoing materials. We have weekly newsletters, monthly publications. We have a quarterly magazine. So I encourage you to sign up if you're interested to receive some of those updates. There's my contact info, and I will turn our time back over to AT because I know we have some questions.
Yes. Thank you all. Thank you to all of our panelists for sharing about fair housing, about your agency, and of course, providing those excellent resources. We are going to jump into the questions and answers session. So if you're an attendee, feel free to put a question in the chat and we'll see if we'll get to that. I'd like to start a question for the whole group. HUD has been focusing a lot of attention on the affirmatively furthering fair housing portion of the Fair Housing Act. How will this focus play into your respective agencies? Can we start with David and then go to Kylene and then Ronell?
Sure, thank you, AT. Well, affirmatively furthering fair housing is an important mandate under the Federal Fair Housing Act to help address the inequities that exist that cause unequal and segregated access to housing across the nation. And while the Indiana Civil Rights Commission, as a Fair Housing Assistance Program, or FAP, is more focused on enforcing fair housing laws, it still strives to affirmatively further fair housing through its robust education and outreach programs. And we're monitoring to see what specific impact the new proposed rulemaking regarding this may have on our activities and partnerships across the state. But we're still going to continue to raise awareness and educate and continue to try to address those inequities through the enforcement mechanisms that we have in place. Go ahead, Kylie.
Well, I was just going to say, I believe HUD is actually accepting comments up through today or tomorrow. So if anyone else would like to weigh in and be heard, it's not too late. I know our National Association of State Housing Authorities is preparing comments on that. One of the big things, I think we try to focus on is just spreading awareness about fair housing and what it means. It's part of the importance of our sponsorship of, not just ICRC, but the Fair Housing Center of Central Indiana, which enables them and you guys to provide training. We actually have started training all of our staff every year in April as well, just to remind them what fair housing is. And even though we're not an enforcement agency, it's important to know because we could be receiving constituent complaints or those sorts of things around it. I think the really important thing is to see that final policy come out from HUD and then to see what updates we want to make to the state's consolidated plan, which is, has annual updates, but really every 5 years gets a real deep dive. But, it oversees a lot of those programs that are, so important to housing development, not just in Indiana, but in some other states as well.
Well, thank you very much. And so let me just go backwards in time in terms of affirmatively furthering for housing. Now, this originated back in 1968, and we're still at that precipice where HUD is still trying to determine exactly how to effectively implement this. And I know that going backwards in time, I think it was during the Nixon administration, his Secretary of Housing was beginning to actually try to do something with this. And I think that initial person who was Secretary of Housing was then neatly disposed of from that position because, it just wasn't, when I say it was not workable, you didn't have public will behind it. So essentially, this is about entities that are receipt of federal funds. And the crux of this is trying to overcome the segregated patterns that were developed through the federal government in terms of what it was doing back in the 30s and the 40s and the 50s, whereby they would be developing communities, and they basically said that anyone would be not white could not live there. So typically what I see on this stuff is for housing organizations that are involved in this and other communities that are involved with it as well. But in terms of our agency having any direct role in this area, it's not an area that we would be delving in. We will do education and outreach, as the other two panelists have said, about this issue, but it's not something that we would be seeking to enforce and recognize. We're talking back since 1968, and we're still trying to affirmatively further for housing.
Thank you. So this is mainly, I think, a question for our civil rights commissions, but beyond investigating discrimination complaints, what other tools does your agency offer to remedy complaints of discrimination? Ronell, you can start first.
Well, with the Civil Rights Commission, which is the Ohio Civil Rights Commission, David, every time you said Civil Rights Commission, I was like, that's us. It's all of us, okay? All of us, I think, involved in this are Civil Rights Commission. So in terms of us, okay, I was very fortunate with my agency that when I came along in the late 90s, we had a pilot program where we put in mediation, okay? And for some reason, I'm not even sure how I was part of that group working on developing this pilot program, because I didn't know that I was going to be in this area. But we developed mediation, and the pilot program, as you might not guess, but it focused on housing, okay? And that's what we did on the pilot program. And I think one of the reasons why we did on housing was because we realized there are so many possible remedies with respect to housing if you're being discriminated against, okay? So this program has been very, very, very successful. We've got a success rate that has stayed in the mid-70s for all the duration of the time that I've been around the commission. But I would say that is the most critical thing that we have. Also, and I'm sure with David, with their statute, it requires us to, during the course of the investigation, during the lifetime of the investigation, it encourages us by statute to continue to try to conciliate, to try to resolve those issues, okay? And so our investigators are uniquely involved in that, as well as our mediators that we have for the 5 different regions. Okay, thank you.
Yeah, like Ronell said, and as I mentioned in my presentation, our mediation and alternative dispute resolution area is robust and has done a great work to help remedy the complaints of discrimination. One thing that we also have, and if a situation warrants it, The Indiana Civil Rights Commission has the ability to file a civil action for appropriate temporary or preliminary relief, such as a restraining order or something pending a final disposition of a complaint. So this could be used to prevent or delay an eviction proceeding, to prevent an aggrieved person from being unlawfully evicted from their residence while their complaint with us is pending. So I think, and from what Kylene had talked about in her, maybe connecting our staff that are doing that with the resources that they have on the ground there in the courts, I think would be a great idea as well.
May I also add to that, and particularly when it comes to filing the TRO, the temporary restraining order, I want to make sure that everyone here understands it is not a slam dunk to get a TRO, okay? Essentially, we have to be able to show if it goes, meaning our Attorney General's office that would enforce this under our statute, we as an agency have to gather enough information to where we would be able to prove that there really would be injury that would occur, and that and no longer saying that under our statute we talk about more probable than not, which only means more than 50%. If you're trying to get a TRO, you have to have almost absolute certainty that you're going to prevail. And that's the disappointing part about the TRO, is because while on its face it sounds like it's a wonderful tool, but in real application, it really is, for me, it's disappointing that it doesn't do what we really wanted it to do. I'm sorry, not the way they intended to work. Okay. All right.
Yeah, we've got a pretty great question in the chat from one of our audience members about how does one establish the connection between a protected status, or what I think we've been calling a protected class, and the decision made by the landlord. They're asking, is the police report how you make that connection? Could someone share kind of how do you build that connection between the protected class and maybe the discrimination basis of that protected class and what was happening?
Well, I'll jump in right away, which is, let me first tell everybody, every one of you who are here today, you all are members of a protected class. The statute is neutral. It is not about only Black people or only people of color. It's about everybody, because as David had said, if you're being treated disfavorably compared to others, not of your particular race, your particular national origin, you can file a charge. Okay. So in terms of I'm going to disperse the thought process that we're trying to do here. And also too, the statute doesn't require that you prove with absolute certainty, as we were talking about with the TRO, that the landlord discriminated against you, okay? All it simply does is go on David's website if you're in Indiana, go into my website if you're in Ohio, file a charge with the respective agencies. We're not asking you to prove that it happened. You just have to have a belief that it's discriminatory, okay? And then we will take it from there.
Perfect. It is 3 o'clock, so I want to be respectful of everyone's time. But before everyone leaves, I want to first say thank you to our panelists. If you would like to get in touch with our panelists, I'm going to share my screen, and you'll have their contact information. You'll be able to see their contact information. Speaking for myself, I found this panel to be very informative and educational, so thank you all so much. Before you all leave, before all of our attendees leave, we want to just remind everyone of one more thing. The Indiana Civil Rights Commission is hosting a conference, which will be held from June 19th through June 21st in downtown Indianapolis at the Crown Plaza Hotel, Union Station. The Civil Rights Commission, in partnership with the Indiana Governor's Council for People with Disabilities, will host this conference in person and virtually through an interactive hybrid experience to foster accessibility and inclusion for all participants. To learn more and register for this conference, you can scan the QR code on your screen, or you can click on the link that should be placed in the chat now. We hope we will see everyone there. And then lastly, we would like to hear from you about today's presentation. You can access a survey via scanning the QR code on the screen or clicking the chat or clicking the link that will be dropped into the chat. It just takes like less than 2 minutes. So we encourage everyone to give us your feedback. And I want to say thank you again to everyone who attended. Thank you to our panelists, and thank you to the team here at ICRC for participating and for helping us out. So thank you all.
Thank you, folks. Thanks, ICRC.
Thank you.